So let's get started properly. Once again, I welcome you to Navigating Risk and Safety, Safety and Risk Intersectional Connections, International Considerations in Family Law Cases Involving Gender-Based Violence and International Connections. I want to acknowledge that our work is located on the traditional lands of the Anishinaabeg, Haudenosaunee, Lenapewauk, and Chinongtong nations. These lands are connected with the London Township and Sombre Treaties of 1796 and the Dish with One Spoon Covenant Wampum. We make this acknowledgement to counter the doctrine of discovery and recognize Indigenous lands and sovereignty. We also recognize that many Black people were violently displaced to Canada through settler colonialism and slavery. We will continue to work collaboratively with communities to challenge colonization, anti-Black racism, and further forms of oppression that remain pervasive in Canada and that result in disproportionate impacts of gender-based violence on oppressed communities. We are very happy today to be joined by Deepa Mattu and Fadwa Yahia. Deepa is a dedicated lawyer and intersectional feminist recognized for her commitment to advancing equity, anti-oppression, and anti-racism. Since 2019, she has served as the executive director of the Barbara Schleifer Commemorative Clinic, where she oversees multiple departments and directs the clinic's intervention and advocacy efforts. She was appointed a member of the Domestic Violence Death Review Committee in 2023. She's received numerous honors and awards for her contributions to social justice and equity. Fadwa practices family law with a special focus on child-related matters and with a focus on parent-child contact problems, family violence, and jurisdictional and mobility disputes, including international abduction. We will first hear from Deepa and then Fadwa before moving into our question and answer session. Deepa, I'm going to pass it over to you to get us started.
Thank you, Katrina. It's an honor to be here with Fadwa talking about this issue. I will start by locating myself and what the clinic does and who we are. So a brief agenda of what I'll be covering in my portion of the conversation today. I'll talk about the clinic. I'll talk about what is the impact by family law cases that involve GBV in the international connections. I'll briefly give you a framework of what is Hague Convention and how it intersects with the family law cases in Hague Convention cases, and what is the treatment of cases in non-Hague Convention cases currently that we see and observe. And then I'll wrap up by suggesting what can judges do to reduce the negative impact on women and gender diverse survivors of violence in these contexts. And followed by me will be Fadwa, who will be sharing with you some very practical and well-needed resources within the context of marshalling a case related to these issues. So there is brief overlap between me and Fadwa in our talk, but I think it is really relevant for the continuity purposes. So starting with Barbara Schleifer Commemorative Clinic, who we are. For the folks who don't know about us, Barbara Schleifer Clinic is a clinic named after Barbara Schleifer, who was an idealistic young lawyer from Toronto, and she was assaulted and murdered on April 11th, 1980. The clinic offers legal services, representation, and trauma-informed counseling and multilingual interpretation to diverse women and gender diverse people who have experienced violence. The clinic was formed in her name in 1985. By her friends and colleagues who were going to be her professional partners and going to work with her. But when her life was cut short, they came together to create the clinic. And over the years of 39 years of her existence, next year will be commemorating our 40th of existence, we have served over 150,000 women and gender diverse survivors of violence through direct service. We also do a lot of advocacy work, legal reform work, and run various projects and programs. In terms of understanding the intersection of gender-based violence and the cases involving international jurisdictions or international movement, I thought that I will give you a framework of what we really need to understand. First of all, we need to really understand the intersection, which means that we need to understand the concept of intersectionality. We need to understand that the gender-based violence experiences in family law have multiple forms of discrimination that actually impact survivors in these particular cases. This could include the race, this could include their immigration status or lack of immigration status, this could include their gender, and many other social aspects, including access to resources, access to language. There is also international connections related to the layers of complexity, which are elements of that international jurisdiction, which is there are different legal systems, there are different cultural contexts within the legal systems, and then there are treaties like Hague Convention or CEDAW that we need to think about. There are also need for addressing and challenges which are posed by different legal frameworks within the cultural norms. So one thing that I always emphasize that you could be having same legal writing or framework in terms of how the law is written, but how it gets applied in a cultural context changes with every jurisdiction based on their own histories. So for example, in the Canadian context, if we think about it, we just started our webinar today with land acknowledgement. We have a history of discrimination and bias that has existed in our legal system against Indigenous communities. And that's part of our history and part of our experiences. Similarly, in some jurisdictions, there are challenges with practices of misogyny and patriarchy, which is common to most jurisdictions. And those are the things that need to be kept in context when we are talking about families who are, moving through jurisdictions and moving through the cultural contexts. There are safety concerns which are also need to be kept in mind or highlighted because there is need for heightened safety. There are risks for survivors with their international ties. These risks include abduction or lack of access to support services or difficulties in enforcing protection orders across borders. But there are also safety concerns that are beyond the survivor herself, which in many cases in the clinic's context, what we see examples of a threat of violence against their families back home, threat of violence against their extended families. Another thing which we see, the risk that comes from that the violence is not necessarily going to happen in an intimate partner relationship alone. It could be that the threat of violence will come from extended family or sometimes people beyond extended family. It could be part of their clan and community. And those are the safety concerns that need to be understood and kept in mind. And then lastly, the intersecting factors that we need to keep in mind in thinking about these cases and evaluating these cases as we think about how to well represent these clients is to think about systemic barriers within the justice system. That means that, we obviously see that marginalized communities could be disproportionately impacted. We see barriers related to lack of access to legal representation, not having adequate resources to have a lawyer who is competent in this area to represent them. These cases are complex, and I think throughout the conversation today, we will understand, if you haven't worked with a case like this, that doesn't mean that you can never work with a case like this, but working with a case like this definitely requires to understand the various layers of complexities that are related to the experiences of these families, especially when there is a survivor of gender-based violence involved within the situation. So I thought maybe one way to look at it at a framework level and to like maybe I'm slightly simplifying it. So I want to do a disclaimer with this slide that this probably doesn't cover every possibility of the situation, but who is impacted by family law cases involving gender-based violence and international connections? So here are some scenarios that I can share with you that I have seen over the years of my work at the clinic and beyond. So there are many parents who face hardship and discrimination in family law cases that involve gender-based violence and international connections. Examples are survivors who have returned to a country where they have precarious immigration status or no status. Immigration sponsorship can be used as a tool by the abusive partners to assert power and control over the sponsored spouse. So that's one example. So this could be that we are talking about someone who's returning to a country which is Canada, or this could also be someone is returning to a country which is not Canada, but the person in this country where they are right now trying to exert their rights of parenting, they don't have immigration status or a naturalized status, or sometimes have no status in these situations. There is also examples that we have seen of families who we have worked with, or women and children who we have worked with, where survivors are temporarily living in Canada. So they have connection to the countries abroad and are moving to another country by either choice or, sometimes not by choice. It's forced because of the circumstances they are in, but they are temporarily right now in Canada, and they're trying to access justice within the Canadian framework because they are right now here. There could also be survivors who have fled across borders in effort to find safe place to live. So that could be that someone has actually reached Canada and is in Canada right now just purely for the purpose that they need a safe haven. And Canada is where they have some kind of connection, which could be sometimes substantial, sometimes not so substantial. They happen to have a way of coming here. They happen to find someone who could help them come here. And Canada is their safe haven for themselves and their child. And that's why Canada is where they will be accessing justice. Or if they are not accessing family law justice system, they are accessing some other form of safe haven system, which could be applying for asylum. But they might find themselves engaged in the family law system because their partner would, or the parent of the child, the other parent of the child, will file a case against them. We also see a lot of survivors with sole or joint custody parenting arrangement where their primary home is being relocated. So wherever they were living before is now being relocated. Again, this can happen both ways. It can happen where someone is moving from here to somewhere else, or sometimes they're moving from elsewhere to here. In this time and age where movement has also fairly become easier, we see sometimes families who have moved through multiple countries instead of just one or two. So it's not those, in the initial ages of Hague Convention cases, there was a lot of this movement of A country to B country or B country to A country. Now we sometimes see that the families have led a lifestyle by choice or sometimes forcibly, where they have moved through many continents or many countries. Sometimes they also move between a Hague Convention country to a non-Hague Convention country and beyond. And then we also see examples of survivors who are leaving or have left abusive relationship and are trying to rebuild their lives and live lives of their children, and are trying to find a new way of life. And their abuser, who in those situations, who probably was not part of the equation for a long time, but now wants to access convention or non-convention processes because the control, which in many cases is coercive control of the abuser, is slipping away from their hands. So these are some examples. And as I said, they are not completely thorough. There can be other examples or other scenarios as well. So starting with Hague Convention, which is the Convention on the Civil Aspects of the International Child Abduction. What is Hague Convention? So starting from the basic, the Hague Convention was concluded on October 25th, 1980. There are some 90 countries which are contracting parties, with Canada being a party from the beginning of this convention. So clearly, not all countries are part of the convention, but there is a large group of Commonwealth countries and there is a large group of non-Commonwealth countries who are part of the convention. Now, sometimes there is a mistake people make. They believe, which is a common mistake, that we tend to think that all Commonwealth countries might be part of the convention, which is absolutely not true. There are lots of Commonwealth countries who have chosen not to sign on. And it's really important as you're issue spotting and assessment of any file related to this to see which country are we working with, and what is their stance on the convention is also very important. As per my assessment, I feel like many times we forget to see if the countries have chosen not to be part of the convention, what's their stance? Why are they saying? What are they saying about? And sometimes there has been a journey with the countries where they have resisted but signed on. So understanding the convention and signatory process and who are party to it and not is important. Hague Convention is important for family law instruments as it is implemented by the legislation in every Canadian province and territory. The Hague Convention intends to enforce custody rights across international borders and secure prompt return of wrongfully removed or retained children to their country of habitual residence. And that's what the intention of the convention was to begin with. The convention also intends to protect children from harmful effects of wrongful removal or retention, also referred as child abduction. Lastly, the intention of the convention is to return children to the country where they are classed as habitually resident, quote unquote, based on the belief that the courts in the country of their habitual residence are generally best placed to deal with the issue of where the child should actually live. So this is what the Hague Convention intends to do. This is what the framework is. We can see that it is close to 40 plus years old at this point. And the globalization and the movement of the families since the convention was originally drafted has also evolved and changed over the years. There are a few articles within the convention which are really important. Article 3, which provides that the removal or the retention of a child is wrongful. What it says is, where it is in breach of custody rights under the law of the state in which the child was, quote unquote, habitually resident immediately before the removal or retention, and those rights were actually being exercised or would have been exercised but for the wrongful removal of the retention. So this part B is where there is a lot of interpretation that needs to be done. And I know Fadwa will talk more about this. Article 12. This is another article of the convention which is really important and relevant for the kind of cases that the clinic works with or intervenes in. This is, if the requirement of the Article 3 are established, the judge is in the requested state must order the return of the child forthwith. So if Article 3 is established, Article 12 actually gives the powers to the judges to return the child to the country of habitual resident. Article 13, there are few other powers given. The judge of the requested state is not bound to the order the return of the child if the person which opposes its return establishes that the person having the care of the person of the child was not actually exercising the custody right at the time of removal or retention, or had consented to, or subsequently acquiesced in the removal or retention. Part B of the same article says, or if there is a grave risk that his or her return would expose the child to physical or psychological harm, or otherwise place the child in an intolerable situation. And this is where a lot of marshalling of the evidence in front of the court comes. Why the person who is opposing it believes that there could be grave risk or harm. The return of the child may also be refused if the child objects to being returned, which is the voice of the child issue, and has attained an age and degree of maturity at which it is appropriate to take account of its views. The judge shall consider the social background of the child provided by the central authority or the competent authority of the child's habitual residence. Moving on, what are the challenges that we have seen over the years in the Hague Convention cases, which involves gender-based violence? The intention of the convention is not being achieved through its current application, particularly when we consider cases of domestic violence. And you would note that I'm using the terminology gender-based violence and domestic violence sometimes interchangeably because as shared with all of you in the beginning, we work from the framework of women and gender diverse people, and hence the language has evolved over the years for us. Domestic violence is common in cases where Hague Convention is implemented. So there are stats available which say approximately 33% of the parents bringing these applications for the return of the child have admitted that they had committed or had been accused of committing domestic violence. So if you think about it, the percentage of cases in which some kind of system, either legal system or justice system or sometimes customary system has been engaged where a reported domestic violence has happened is 33%. And then we can think about in how many cases women do not report. And there is a whole conversation about why women do not report, why reporting can sometimes actually increase the risk of violence and lethality. And therefore women in many situations decide to take alternate actions rather than reporting the violence. This ultimately has a negative impact on women's rights and their safety and that of their children. Other areas of convention that we find sometimes can be problematic in these cases or create challenges are that convention has an expansive reading of custody right. This gives almost any parent the right to bring these applications, regardless of their actual involvement in the care of the children. So if you remember, when we were going through the articles, that was one of the areas that was giving any parents to come forward. If someone has to come forward and decide that I'm going to come forward with the application, you don't have to actually show what your role in this child's life had been. The court struggled with how the habitual residence is determined. Ultimately, long and drawn-out court proceedings can be used as a tool of continued abuse. Sometimes not necessarily in the jurisdiction where the Hague Convention applications are brought. At times, this long and drawn-out court proceedings can actually happen in the other jurisdictions, which is where the child is removed to. Now, one of the leading cases, which we all know about, which guide us in Hague Convention cases here in Canada, is Belev. It is a 2018 Supreme Court case. And it was a case which OCL took to the Supreme Court. The brief facts of this case were that respondents were married in Ontario and moved to Germany in 2001, where their 2 children were born. The father gave his time-limited consent for the children to move to Canada with the mother for 2013-2014 school year. The father purported to revoke his consent, resumed custody proceedings in Germany, and brought an action under the Hague Convention for an order that children be returned to Germany. the father requested that his Hague Convention application be set down for hearing before the Ontario court. This whole case created an environment where actually the children were ordered to be returned back to Germany, and then a German court decided for the children's custody rights, and they were, by that process, they actually came back to Canada. But the case, by virtue of the appeals, went to Supreme Court. The question before the court obviously there were complicated facts, but the court definitely looked at how should an application judge determines the question of a child's habitual residence. And within that analysis, there were three possible approaches that were discussed or have been usually discussed in these cases. One is a parental intention approach, which in simple words, and I'm obviously simplifying some of this content here for this purpose of this discussion and presentation. The parental intention approach dominates Canadian jurisprudence, and it determines the habitual residence of a child by the intention of the parents with the right to determine where the child lives. The child-centered approach, which emphasizes the situation and perspective of the children at the time of the application for their return to the original country. And then comes the hybrid approach, that the judge considers all relevant links and circumstances, the child's link to and circumstances in the country A, the circumstances of the child's moving from country A to country B, and child's links and circumstances in country B. So this seems like the most holistic kind of approach. Clinic intervened in this case as a public interest intervener. Our position in the case was that in the cases where there is domestic violence and abuse, the parental intention approach generates an unjust result. Parents looking to leave an abusive relationship must rely on the consent of their abuser to remove the children from that environment, and find somewhere safe and comfortable for them to be, which also means that it actually opens them to a possibility of very high risk situation where they are being expected to actually go through the parental intention and collaboration. Saying that, the court favored the hybrid approach. It empowered the application judges with the necessary authority to consider relevant factors in determining a child's habitual residence. It doesn't necessarily fully give a very in-depth analysis, requires an in-depth analysis on the experience of the domestic violence by the woman herself in the situation, but at least within the relevant links and circumstances and child's links to the circumstances where the movement happened, there is enough in front of the application judge that can be presented and analyzed, is our opinion. What happens in a non-Hague Convention case? Now, non-Hague Convention country, to begin with, if we think about, as I said, that there are lots of countries which we might assume thinking, oh, this country has a democratic framework, or this country is really big now, and they have they're very well known, and you will be surprised that many countries like those which we might think are progressive and have all the systems in place, have actually not signed on to the Hague Convention. And definitely, it is quite difficult to get a child returned to Canada from those countries. So once a child is removed to those countries, and in clinic's experience, that's one of our experiences and which we have been challenged with multiple times over, and have collaborated with folks like Fadwa in problem solving, or Global Affairs Canada in problem solving. What do you do in jurisdictions where your child is, or the child of the family of the mother is stuck in a non-Hague Convention cases? In Ontario, with respect to the non-signatory countries, the Children's Law Reform Act, CLRA, applies, which means that if a child from a non-Hague Convention country is here in Canada, the CLRA discourages child abduction by confining Ontario jurisdiction over the custody to limited circumstances. Now, there is Section 23 of the CLRA that carves out the exception where the child is physically present in Ontario and the court is satisfied on a balance of probabilities the child would suffer serious harm if removed from Ontario. The serious harm analysis under CLRA is less stringent than the intolerable situation test that is under Hague Convention. But nevertheless, there is a two-step analysis, and in Hague Convention cases, while Ontario courts can have confidence that whatever jurisdiction decides on the child's custody, it will do so on a basis of child's best interest. Ontario courts cannot always have the same confidence in the Section 23 cases, where they are actually making a decision to send a child back to a non-Hague Convention country. In 2020, there was Ontario Court of Appeal case, MMA versus DME. This is another case where the clinic had intervened and has kind of given us a really good direction in cases of non-Hague Convention cases. And especially a non-Hague Convention case where the survivor and the children involved have made a refugee claim in this country. So if you remember, at the top of this presentation, I presented various scenarios which can happen in these kind of cases. And one of those scenarios was where the mother or the parent who's aggrieved and is experiencing violence and is in an abusive relationship comes to Canada and applies for a refugee case to get asylum. Now, in this particular instance, the quick snapshot of the facts is mother brought her 3 children from Kuwait to Canada without the father's consent. She claims she fled an abusive relationship that put the children and her safety at risk of serious harm. The father claimed that the mother kidnapped their children. The mother also applied for a refugee claim. Kuwait is not a member of the Hague Convention. Mother asked Ontario to exercise jurisdiction to decide her custody claim under Section 23 of the CLRA. The court must find on balance of probabilities the children would suffer serious harm if they're removed to Ontario. The application judge found that there was no risk of serious harm to the children and ordered the children be returned to Kuwait. The mother appealed, claiming that there was error in determination of the serious harm. The Ontario Court of Appeal decided that the children's refugee claim must be resolved before considering their return to Kuwait. The clinic's position in this case, which kind of gives you an insight into what has been clinic's experience in many of these situations, is that Ontario courts must be aware that they cannot always have the same confidence in cases under Section 23 when a non-signatory state is involved. Family court should consider the legal framework of CLRA in its entirety and read Section 23 through GBV lens, which would include the harmful effect of domestic violence on children and include making decisions based off the best interest of the children. To ensure the safety of the women and the children, the family court's analysis must be mindful of the effect of the decision on the refugee determination process, and the evidence of serious harm must be considered in the context of GBV and the adequacy of the social and legal systems of the country of habitual residence to protect against the abuse of women and children. And that's the piece which remains most controversial because if you remember, in the framing of the conversation, I said to you that there could be one way the law is written and there could be other ways the law is applied. And how the law is applied then becomes or comes down to what is the evidence in front of the court. It could be expert witnesses, it could be country conditions, and many other important factors which Fadwa will guide us on in her portion. So, I'm sorry, I moved it too quickly. So here are some of the recommendations that the clinic has been working with. The clinic believes that the violence against children includes the effects of witnessing violence against their mothers, and the health and the safety of the mothers has a direct impact on the health and safety of the children. This we don't say necessarily only in this context. These are the broader recommendations in the context of where international jurisdictions are involved. Family courts must consider the likelihood of the parents who abuse their spouses to also abuse their children. The interpretation of the domestic law must be interpreted in the light of the compliance with the Canada's positive obligations to provide state protection to victims under international human rights law and treaties, including CEDAW. To ensure the safety of the women and children, the family court's analysis also has to be mindful of the effects of their decision on the refugee determination process. There is need for the discussion of strategies for developing parenting plans that prioritize the safety and well-being of the survivors and their children. This includes considerations for supervised visitations, remote and Zoom connections, and the clear communication protocols, which doesn't necessarily, if I may add, which doesn't necessarily, put these very complicated responsibility on the survivors to continue relationship which create coercive control and litigation abuse against them with their own abusers. And then identifying systemic barriers within the justice system that disproportionately affect marginalized families. This includes biases in the legal proceedings, lack of access to legal representation, and inadequate support services. How can the negative impact on survivors be reduced? To ensure that the intention of the convention is met, a fulsome reading of the convention as a whole is required. So section 3, 12, and 13 work in conjunction with each other. They shouldn't be read in isolation. Family court should take an intersectional, nuanced, and trauma-informed approach in the reference with the refugee and non-status women and children, especially within the cultural context. The lawyers and the judges both should be alert and alive to the experiences of the abuse. There is situation of sexual abuse involved in these cases. There is situation of language barriers involved in these cases. And it is really, really important for the legal actors, which I would say everyone involved who acts as a conduit to the justice system or a decision maker, that there should not be trivialization of the violence and or mischaracterization of the violence. Family courts ought to consider the risk associated with the return of these families or the refugee claimants and women to the children of their to the country of their aggressors, and the impact on the safety of the women and fleeing domestic violence. And I'm not saying this for shock value, but unfortunately what happens is when the families are requested to remove, they are beyond the jurisdiction of the Canada. And I have seen cases of children dying. I have seen cases of mothers dying. But unfortunately, by that time, it's too late for any judicial process to intervene at any given point of time. And those examples don't go back in the cycle of informing the system. And that's probably one of the big gaps that we see in terms of understanding the associated risks of returning these families to these countries where there is persecution or the countries of the aggressors. Family courts should consider risk associated with the return, and they should do a proper risk assessment is one of the suggestions that we have been making for a long time. And we invite all legal actors to engage with some kind of risk assessment modalities. And in summary, a comprehensive and empathetic approach is essential in family court proceedings involving refugee and non-status women and children. This approach is not only to uphold the principles of convention, but also to promote a more just and equitable legal system. With that, my portion of the framework and giving you a big picture sense of what is happening and what the clinic's experience is comes to an end. I want to thank you all for listening to me, and hopefully, I'll get to interact with some of you through your questions. And I now invite Fadwa to present her part of the presentation.
Good afternoon, everyone. I'm thrilled to be presenting today, especially with Deepa. This is a topic which is close to my heart. I could talk about it for hours, but I've promised everyone that I'm going to stick to my allotted time because I think it's important to save a little space for some discussion. As Deepa mentioned, the focal point of my portion of today's presentation is going to be on the practical approach to these cases. I have a PowerPoint presentation which sets out the necessary information and should serve as a useful foundational guide for how to navigate these cases. But again, in the interest of time, I'm not going to go through each slide individually, and I'll be supplementing some of the information as we go through our discussion today. So getting started, global trends and migration patterns are obviously the driving force behind the increase in international child abduction. People are rarely living in one place alone. They work abroad. There are more cross-cultural marriages, and these factors underlie the cases that we often see. That being said, from a theoretical perspective, Canadian provinces treat child abductions from non-signatory states in a manner that is comparable to the Hague Convention. The guiding principles are the same, first by declining to decide parental disputes on the merits, and then secondly by favoring the return of children to the jurisdiction of their habitual residence. However, these foundational similarities do not mean that an application is brought under provincial legislation is treated in the same way as brought under the Hague Convention, although both of them are addressed in the CLRA, the Children's Law Reform Act, because the CLRA has adopted the Hague Convention. And so perhaps this might be a good place to quickly point out that the family law rules were amended to provide application judges with the necessary management tools to conduct the application quickly for all international child abduction cases. The longer that a child is in a jurisdiction without adjudication, the more difficult their return will be. And the necessary rule that we're referring to is 37.2 of the family law rules, and in particular subparagraph 3, that provides that an international child abduction case shall be disposed of promptly and not later than 6 weeks after the case is commenced. And the same timeline also applies for cases involving non-signatory states, as set out in the case of Lee versus Rubio. Justice Bonato made that comment in that case at the Court of Appeal. So the bottom line is that it's a process that will essentially move at warp speed. And so you have to be prepared to act quickly and efficiently and marshal evidence immediately. And I know that it may sound a little silly, but Deepa touched upon this as well. When an abduction case lands on your desk, the first thing that you need to do is consider whether the country in question, the left behind jurisdiction, is a signatory state. You don't want to make any presumptions. Countries like Burkina Faso, Botswana, Lesotho, Tunisia, Morocco, Iraq, Zambia, and Zimbabwe are all signatory states. But it's not only important to determine whether or not they're signatory states, there are sometimes limitations on the extent to which they are willing to comply with the convention. So you want to look at the limitations on their status as well. And this is important because you want to make sure that you're following the correct path in terms of commencing the proceedings or perhaps responding to them. So we'll start with Hague cases. in terms of the preliminary considerations. So what are those preliminary considerations? First is whether the child is 16 years of age or younger. Why is this important? Because the Hague does not apply for children over the age of 16 years. They're effectively able to vote with their feet, as they say, or make decisions independently. And so the Hague applies to 16-year-olds and under. And then you want to look at, did the left behind parent have a right of custody? And were they indeed exercising this right? And then you want to consider whether the child was habitually resident in the left behind country. And so if the answer is yes, then there are you want to consider whether there are circumstances or exceptions that might prevent the child's return. So where do you start that application? It's always in the jurisdiction where the child has been taken, and you can do so in either the Superior Court of Justice or the Ontario Court of Justice. You want to look at which way you want the hearing to take place. Is it by way of motion or trial? Hague cases are often decided by motion, but I would recommend a trial or some kind of hybrid version of a motion. And I say this because really there's nothing better than oral evidence in these types of cases. And do not dismiss the utility and function of cross-examination. You've got competing stories. Credibility is certainly going to be at play. And so if you've been given, and that's why oral evidence is really key. Judges get to assess credibility, and it's best done when people are testifying. But if you've been given a motion date to argue, make time for questioning. In accordance with the family law rules, and ensure that it's not just questioning, which is more of a fact-finding exercise, but that you also engage in cross-examination. And then what you want to do is expedite the transcripts and use them as part of your arguments at the time of the motion. Moving along, when we look at judicial resources, as I mentioned before, the courts have an obligation to expedite these matters. And so again, don't underestimate the power of engaging the courts to assist with answering questions, both in terms of procedural and enforcement with the left behind state. So in Ontario, who do you call? It would be the Honorable Justice Stevenson out of the Toronto Superior Court of Justice, in conjunction with your local senior regional justice. So if your case is in Brampton, you're going to connect with Justice Zymus. If it's in Milton, it's Justice Coates, and so on and so forth. And so your local senior regional, along with Justice Stevenson, may then connect with, depending upon the jurisdiction in the receiving state, connect with the Associate Chief Justice O'Neill, who will then coordinate those calls. Sorry, looking at a determination of habitual residence. Deepa has gone through that section quite comprehensively, so I'm not going to repeat what she said about it, other than to simply point you to the case of Ludwig versus Ludwig, which sets out a step-by-step guide to be considered along with bailiff when you are looking at habitual residence. And so I'm going to move us along to Article 13B, which Deepa also went through, and she talked about the exceptions to a return, which are under Article 13B and something called the grave risk of harm. And the only important takeaway that I wanted to add on is that this is a rather stringent test, and it has to be more than an ordinary risk, rather like it has to be substantial. So the test is really that it's exposing the child to an intolerable situation. And the higher threshold really stems from the assumption that the receiving state is equipped to address those risks of harm to the child. And so it's a higher test. So when we look at what does that mean in terms of the domestic violence considerations and from that perspective? The Hague wasn't initially attuned to intimate partner violence or children's rights as individuals at the time of its inception. However, as time started to pass, it recognized that there might be situations where women and children were being returned to abusive situations, and that the convention itself wasn't providing adequate protections. So there's something called the Guide to Good Practices, and I recommend it's available online that everyone have a look at it. That set out considerations when dealing with domestic violence allegations, including the veracity of those allegations, the nature of the violence, looking at whether they're isolated incidents or whether there is a pattern of coercive control, and then certainly the adequacy of legal protections that are in place for you to be able to address the allegations of domestic violence. So from a practical point of view, where counsel is dealing with these allegations, you want to address all of these considerations when advancing a 13B argument. So the other thing that I want you to keep in mind is that the onus when you are making a 13B argument is on the person advancing it. So if your client has suffered domestic violence, you bear the onus of proving that violence, of proving that there is a grave risk of harm and that it is an intolerable situation. And that you also have to demonstrate, as Deepa said, that a threat to a parent is indeed a threat to a child, and that you need evidence in those circumstances that police and other agencies cannot protect the woman or the child. And so you may indeed need expert evidence to demonstrate how that receiving jurisdiction, where the underlying presumption is that they will be able to protect the individual, the woman or the child, is not equipped to do so. Okay, so let's and so you want to also similarly point out to situations where previous court orders have not been followed. So you want to look at all of those circumstances which might demonstrate that, as I said, the receiving jurisdiction is ill-equipped to be able to address the seriousness of the allegations and the domestic violence that's been experienced. So when we look at undertakings, when we're looking at that, the prospect of a return, if it's being contemplated, undertakings are used to alleviate some of that harm. And I've set out a series of examples here on this particular slide and within the entire slide deck that include ways in which you can sort of minimize that harm to whatever extent. So again, if there is domestic violence considerations, they haven't risen necessarily to the level of intolerable situation. There is, the court hasn't deemed it to be a grave risk of harm. Don't dismiss the utility and the importance of still having to address the domestic violence allegations, and you do so with undertakings, you do so with parenting plans, you do so with terms and conditions. So some of those terms and conditions include no contact orders, suspension of parenting or supervision orders, anything that might be useful in protecting the parent and the child when faced with a return. I'm going to take a moment to talk about best interests. before we move into the non-signatory states, because this was the subject of the decision in FVN, which went to the Supreme Court of Canada. That's what the Supreme Court of Canada was essentially addressing. And they indicate that any analysis involving children means considering their best interests. However, when addressing abductions or return applications, we are only considering those factors that inform a determination of jurisdiction and not a determination of custody on the merits. So best interests in the context of non-Hague cases is more important than in Hague cases, because as Deepa indicated, we have assurances that Hague signatories are guided by best interests. It's a fundamental principle of the Hague Convention. We don't have those same assurances with non-signatory states. They may apply best interests in some cases, but they may not. And because we're not sure, the analysis that we are undertaking must focus on the best interests of children. And again, Deepa went through the considerations, the principles of how courts determine jurisdiction in non-Hague context, including the relevant sections starting with 22 sub 1. And so my comments are really just going to focus on, or the piece that I'd like to highlight on, is the current debate over habitual residence. So unlike the Hague Convention, which does not define habitual residence, the CLRA does indeed provide a definition. However, in recent years, confusion has arisen regarding how best to interpret habitual residence. The question is whether we use a strict application of the legislative definition, or do we import Hague principles, which were set out by the Supreme Court of Canada and Bailiff. And you've seen a series of cases that have done both. You have some judges who are applying an interpretation of the legislation, some that are importing Bailiff, and some that are doing a combination of both. And so this question is going to be answered by the Supreme Court in the case of Moralian versus Dunmore. Leave to appeal was granted by the Supreme Court of Canada, and it's going to be heard in December. So it's going to be quite interesting in terms of determining what they're going to find habitual residence to be. So in terms of serious harm, again, Deepa has set out the test, which is less stringent under Section 23 of the CLRA. And rightfully so. As we said, we're not always certain that best interests are going to apply in non-signatory states. And so the threshold is not grave risk, it is serious harm, and it's not an intolerable situation. The comment that I wanted to add here relates to the potential for the application of foreign law and the fact that in certain circumstances, it may be considered serious harm. Think about the application of laws that might be rooted in religious or patriarchal traditions, or where gender roles are defined in a discriminatory or limiting fashion, or where physical discipline of a partner or a child is permitted and doesn't fall under the ambit of IPV. Or it's not considered domestic violence as we know it. So in these circumstances, be prepared to obtain expert evidence that speaks to this issue. And an important note that practitioners need to take away is that Canadian courts cannot take judicial notice of foreign laws or their interpretation and treatment. And so you will need to retain a legal expert from the foreign jurisdiction to speak to the application of laws and to prepare an expert report. And in some circumstances, you may even want to retain an expert with some sort of social science expertise in that jurisdiction to speak to how domestic violence and IPV are addressed or perceived from a cultural standpoint. So when we consider, again, the best interests of children under the Section 23 analysis, the focus is indeed on an individualized assessment of the risk of harm, and the best interest test that we find under Section 24 of the CLRA will only apply to the extent that they establish serious harm. So I wanted to clarify that, and that also comes from FVN. So what happens if the court has determined that a child has been wrongfully retained or removed? This is where Section 40 is invoked. And a court in these circumstances can exercise a series of options, including making interim orders in respect of the custody or access of a child as the court sees fit, staying an application subject to other steps taking place, including the commencement of an application in the foreign jurisdiction, or finally, ordering the child to a return of an appropriate place. Note, we don't use the words habitual residence in this section. They don't appear anywhere in Section 40. And that's an important distinction because it gives the court broad powers to determine the most appropriate place to send a child. So unlike the Hague Convention, which mandates the return of the child to their habitual residence, Ontario courts have the ability to be more expansive in determining where a child should be returned. So part of that, I apologize, I skipped ahead a bit too much, is undertakings in relation to the return of children. So undertakings are a regular feature of Hague applications, and that's because signatory states warrant and undertake to reciprocally enforce orders and agreements. There are no such assurances with non-Hague signatory states, and yet the Supreme Court of Canada in FVM decides that undertakings are a good way to assist with returns and to alleviate, again, some of the concerns that may have been raised, but were not accepted as rising to the level of serious harm. Unfortunately, the Supreme Court gave us no direction in terms of what undertakings should look like or how they should be enforced. And the biggest question for me in particular and for other practitioners is how on earth do we enforce these? Non-signatory states owe us nothing in return. Again, there's no duty of reciprocal enforcement. Nevertheless, it doesn't mean that we dismiss the function of an undertaking. And so what I have suggested that we do in some circumstances is look to how other countries have addressed undertakings. And the case of Golan and Saada is a case coming out of the United States. It's a US Supreme Court decision. And it basically highlights the pitfalls of undertakings and parenting plans that are formulated in conjunction with return orders. This case involves a Hague jurisdiction, but I think the principles are important here because they warn against the imposing measures that are not raised by the parties, that are raised by the courts, or that are unworkable or will not be reasonably followed. And they also say that it's important to consider that some undertakings and other measures will not be enough to ameliorate the potential for serious harm. So we have to be mindful of this when undertakings are being proposed, particularly in situations of domestic violence. You need to know that they are going to be workable solutions, that we are not sending women and children back to situations of where they may face harm or threats to their security. So in the situation where undertakings are appropriate, if they're appropriate or you have no other choice, be intentional in the suggestions that you make and ensure that they are workable. As counsel, you have to be creative and offer your client options that are going to assist them in the long run. Take the steps, use Section 40, get interim orders made because the court has the authority to do so, to require a series of terms and conditions to be satisfied in advance of the return of the child. So if housing is an issue, you want interim orders to be made where the other party is securing housing. to ensure that the child and parent have some place safe to return to. You want to ensure that any other orders that have been made for supervision are in place and are enforceable in that foreign jurisdiction if there are contact problems or concerns that a child may be subject to abuse. So look at all of those considerations. Look at logistics, look at financial issues, look at immigration status, look at the withdrawal of criminal proceedings, look at incidents of abuse and how best to protect the parent and the child from that kind of exposure. So really, this is where the creative work of legal counsel come into play. So I have finished my slide deck with a series of resources that I hope will also be useful to you in terms of assisting you in dealing with these types of cases. Global Affairs Canada, Canada Border Service Agency, the Royal Canadian Mounted Police, and certainly the Central Authority. There are other resources that I'm happy to share. And again, thank you so much for giving me this opportunity, and I'm happy to answer questions as they arise.
I just want to start by saying thank you very much, Fadwa and Deepa, for your presentations. I certainly found them very, very interesting. There's definitely a lot of complexities to consider. I want to start with the question about, and Fadwa, you are answering this a little bit. So in cases that are involving non-Hague countries, one of our audience members said, I would guess it's necessary to try to bring in an expert opinion on the cultural, legal, or social context of the other countries. And you started to talk a little bit about the need for that expert. So, do you have any experience with this approach? How open are judges to accepting those kinds of arguments? How welcome are those?
I do have experience with it, and I would say the courts are most certainly open to and welcome expert evidence. As I said, they can't take judicial notice of the things that are happening in foreign jurisdictions. So quite frankly, it's incumbent upon you as counsel, if you're advancing any argument in relation to serious harm, to substantiate that with expert evidence from that foreign jurisdiction. So there are, the courts are welcome to it. They are looking for that type of guidance, and it's going to assist them in making those determinations, because simply producing a series of literature that you can find online, there's judicial notice that's permitted to a limited extent of that, but what they're looking for is concrete evidence from experts that can tell us, are police actually prosecuting domestic violence cases? How often is it being reported? Are these protection measures really taken into place? And so experts are best positioned to be able to give that information. So absolutely use that tool and do so regularly. And so when you're looking at timelines with a judge, factor into that timeline the production of those expert reports, the potential for cross-examination of those experts, and the use of those materials in the argument of your motion.
Okay, thank you. So welcome, Lisa. You are on mute, though.
There we go. Can you hear me now? Good, thank you. Another question, considering the likelihood that the survivor parent who's, say, come to Canada with her children has experienced significant abuse that she's fleeing from, and is trying to deal with litigation in a country that is not necessarily one that she understands the legal system, how would you suggest that the mother and the children both could be best supported? Do you have any tips or suggestions around that?
Deepa, do you want to take
Yeah.
that on? Yeah.
Yeah, I can start, and I'm sure, Fatwa, you have some tips to suggest from your practice as well. Like from the clinic's perspective, I think it's really important that the mother actually connects with someone who is reliable and can connect them to a proper competent representation. This area, as we all have, kind of observing and understanding, is complex. It's layered. There are not lots of people who practice in these cases because they happen. There are lots of these happening. That's the trend I am observing, but they happen in pockets, and they are quickly decided at times without actually getting the community involvement happening in a fulsome way. So I think uh, my request to the lawyers in the room is that if you happen to be involved in a case where you are being brought up or you happen to be assisting a client, please do get in touch with the community agencies and supports available, because there is a lot of ancillary work that community supports can provide to the mother as well as the child. There are lots of great agencies like Schleifer Clinic or Center for Refugee Children or Canadian Center of Refugees, where the refugees are involved. And if in the cases where there are non-refugees are involved, there are other social service agencies that could also support. In terms of the children in particular, I think my understanding is the Office of Children's Lawyers is automatically given a notice if the child is there is an application to remove a child from Canada, if that is being moved by the aggressor or opposite party. And they definitely are a great resource. They probably have the most experience in terms of engagement in these cases and presenting these cases in the front of the court. And I think getting in touch with them as a practitioner, I think, is also really important. You might not be on the same page all the time because the child's interest and your interest might not, your client's interest might not be 100% aligned, but they are important stakeholders. You need to know how to get in touch with them, communicate with them, and then see where you could align, or where at least you can come to agreement on some basic facts or basic things to proceed the case properly. Fadwa, I'm sure you have some more tips to share on this.
I do, but Deepa, you've given some great examples. It's not uncommon that the individual from the left behind country or the receiving state is unfamiliar to one of the parties, especially in this day and age where people are living in countries and working in countries that are not necessarily connected to their own cultures, or their, is foreign to them in some way. So other than those community resources, certainly you would, again, it would be connecting with other community resources to make sure that you have the right kind of legal expert, that you understand how the legal system functions in that foreign jurisdiction, so that you know what's going on, because sometimes there are applications that are being started in that jurisdiction and neither one of the parties have a connection to it. And so you need to understand what your rights and obligations are in accordance with that country. And so a foreign legal expert is important. And the best way to find one is probably through community connections, as Deepa said, in addition to the other supports that they provide. So understanding the legal system in the foreign jurisdiction is going to be of critical importance.
I'm just thinking about the complexity in some of those cases that we talk about, and it's not just 2 countries, it might be 3 countries at the very least, and it might be another country in between. It's very interesting. Somebody had a question that I thought was a really good one. You talked about the importance of the age of 16. Have any of the cases so far kind of come up against a child whose chronological age is 16, but for various different reasons, mental age or developmental age is not 16? And is there any provisions around that?
Certainly that's an argument that'll come up. I don't know any cases off the top of my head that have addressed that, but I'm certain that they have. We run into that issue even within the regular context of parenting decisions and cases involving children. So certainly that would be a consideration if the child is, as you mentioned, chronologically the age of 16, but for capacity reasons is unable to make those decisions. And certainly that's going to factor in to the assessment as well. So yes, age of 16 generally, if their capacity is equivalent to their chronological age, then the Hague Convention would not apply. But I would be I doubt that there wouldn't be a situation where arguments could be made that the Hague could apply if there are capacity issues. Certainly, yeah.
And overall, Katrina, I think it's a good question, because the age does become a factor, as Fatwa is saying, routinely in many of these cases, especially because the age of the child is dealt with in different legal jurisdictions differently. Even within the Canadian context, we know that this has been a topic of evolution of our understanding, right? From where we were like a decade back to where we are now, there is an evolution that has happened. So in many legal jurisdictions, the age of the child is sometimes just that alone is the reason why they would make some of the decisions around custody. That alone could be the reason. They would not even look at any other circumstances. The gender and the age sometimes is the only factor that they're analyzing. So I really like where you went with it, because I think that is an important consideration in evaluating the case and issue spotting. What all issues are you all going to be dealing with?
Thanks, Deepa. And this is another question that sort of arises from some of the comments that you were making earlier. Can you dig in a little bit deeper, talk about the differences between the child-centered approach and the hybrid approach?
I will let Fadwa deal with that first, because I have to say that, I have a deep privilege of working from a very specific angle of gender-based violence, and I don't want this to be clouded by that alone. So I will let Fadwa start, and then I'll insert my analysis.
Thank you.
So the child-based approach, so the bailiff tells us that the best way to do this is through a hybrid approach, right? So we're looking at, we're not just looking at the parental intention piece. We're not just looking at the perspective of the child alone, but we're sort of merging the two. Ludwig is a great case that sort of addresses that specifically. And so the court is really looking at links to circumstances, and really the child's links and circumstances in country A, the circumstances of the child's move from country A to country B, the child's links and circumstances in country B, and then in addition, other factors, including the child's nationality, duration and regularity and conditions and reasons for the child's stay in the current country, and circumstances surrounding the child, that like parental intention. So it's a mix of the two that the courts are really looking at. The parental intention, which used to be the guiding force. Where did these parties intend for this child's habitual residence to be? Bailiff raises the circumstances of the child's perspective. And again, arguments being made as, children that are rights bearers, they're not property. And so they also have an important, that their best interest should factor into that. What was the focal point of their life? And it may have, given the passage of time, suddenly become the current country that they're in. And so the courts say now we have to look at both. We cannot simply look at the parental intention in isolation. We can't look at children alone and what's in their best interest alone, but to sort of look at both together. And so that's where bailiff comes in terms of the hybrid approach. And Ludwig gives you a step-by-step analysis of how to do that and the questions that you have to answer. So it's a great case, a reference point case.
So just a quick follow-up to that, because I'm not sure, are children considered parties to those applications?
Yes. So the Office of the Children's Lawyer is automatically now, and they're given notice. They're not parties per se in terms of the proceedings. They're not listed as parties, but certainly their voices, their views and preferences are taken into consideration. It's one of the factors that makes its way into a best interest analysis. Best interest is the guiding principle, as we've said. It's the paramount consideration. And so the Office of the Children's Lawyer will represent the interests of children and will present those views and preferences for the courts, the benefit of the court in completing that analysis.
Great,
And
thanks.
and Lisa, if I may just interject by saying, when I said, Fatwa should answer that question, because the clinic's position has been that within that analysis of, conditions in the country A, movement to the country B, circumstances there, and relationship to the country A back, that holistic analysis of parental intention and the best interest of the child should encompass the experience of the violence in this family. That analysis, and that's, I think, is incumbent upon the lawyers in the cases who are pleading these cases, right, who is representing the mother, as well as sometimes the OCL who's representing the child. I think these parties are the ones for them, which is their responsibility to bring those circumstances and the facts in front of the courts. Now, Katrina, and your center's work for institutions work for so many years. I think you both are pretty much aware of the fact that you have observed this time and again that family courts don't necessarily look at the experience of the violence of mother as a violence against the child, right? There is no direct interpretation of that established, even though the case observation, the science behind it, and the pattern of the cases speaks to that pretty clearly. And that's the piece where I feel like the clinic keeps on pushing that argument in all of these cases, and we want that to be seen in a different light. That an experience of violence of both, and I'm okay to say up to a point even that experience of violence in the family means there has been an impact on the child. Even if you don't say it's mother, it's the impact on the child. I think that's the piece that needs to be in front of the court. And we sometimes feel that that's not necessarily what gets in front of the court as clearly as it could be. And that's where I feel like there is a need for more collaboration and more involvement of the community agencies, which probably can help you in basically deconstructing those experiences and how they impact children.
Yeah, marshaling the evidence in domestic violence cases is unbelievably difficult. And we're talking about a 6-week turnaround time. So that's when I say we're moving at warp speed, you are moving at warp speed. You have barely enough time to scratch your head as counsel. And you've got, and sometimes it's an individual who's come to this country and they've left everything behind. They don't have access to their records. They don't have, nothing is easy to obtain. So it is very difficult to prove those cases. So you do the best that you can and get as much evidence and information as you can in the circumstances. It is not an easy endeavor, certainly.
Thank you.
Okay, I'm going to ask another question from our audience that comes from a slightly different angle. And so in this case, the question is about what if it is the abusive party who is threatening to take the child to another jurisdiction? So what is your steps there? So presumably that's not yet a Hague case, but it's one where people can be concerned about this being an action that is taken.
Yeah, certainly in those circumstances, we have provisions for that under the family law rules where there is a threat of abduction. So what you want to do, depending upon what stage you are in the case, if you haven't got a case before the courts and they have threatened to remove the child, and that is a real threat, you believe it to be true, and that they can facilitate that. You're right, it hasn't made its way into a Hague abduction case, and it hasn't yet made its way into a non-Hague if they're threatening, depending upon the jurisdiction. But what you do is, if you haven't started proceedings, you bring an urgent motion before the court and you institute a couple of important orders. One, non-removal clauses. You obviously want to declare the child's habitual residence to be Ontario so that you can ensure that this court assumes jurisdiction over that child. You want to determine whether or not, if you had an Ontario area order, if they've managed to remove that child, to what extent it can be enforceable in the foreign jurisdiction as well. So you want to move quickly, you want to get an urgent order, or you want to get an urgent motion going, you want to appear before a judge, you want to obviously restrict the child's movement, get a police enforcement clause in place, and then you want to register that order with Canada Border Service Agency and with various embassies. The Canadian Embassy has places where you can register your child with them in that foreign jurisdiction. And obviously hold on to passports, right? So if you've managed to got passports, that child's foreign passports also become relinquished to the party who is staying or are taken away from the party who's threatened to take the child. Sometimes we write letters to embassies letting them know not to issue foreign passports for children who may be dual citizen holders and can have foreign passports done. There's a whole host of things that you can do in those circumstances. But again, it takes a lot, like it's creativity, it's understanding the circumstances and taking the necessary steps that you can, short of chaining your child to their bedroom door, right? Yeah, I say that in jest, obviously.
I also want to say that if you are a practitioner working with someone and your client tells you that this is what is the plan that they are making, this is what they think, they are so exhausted with everything they have tried, then remember that as lawyers, there is a whole professional responsibility and ethical issue that kick in. I know that everything else is client solicitor privilege, but when it comes to the harm to a child or possible abduction, get on the call with the professional responsibility office quickly, get support for yourself, take the right actions that you should take as a lawyer. So remember that you have responsibilities that are tied to your role being as an officer of the court along with being a lawyer of the client. And this is one piece which at the clinic we do the risk assessments and we evaluate this on a very routine basis. So I always say to the lawyers, that's one piece of the duty to report that we sometimes have to keep ready in your back pocket all the time, because these situations can happen. And the dual passport fatwa is really, really important because, as practitioner, I can tell you that's a blind spot that can happen very easily. And you might not, you might have the Canadian passport with you and you might think everything is good. And here is a country which issues a passport very easily to their dual citizens without checking with what is the status of their second passport.
Without consent of both parents being required. One parent can apply for and obtain a passport quite easily.
Magically, very quickly. Yes. So all sorts of things can happen.
Thank you so much to both of you. I'm afraid that's all the time that we have for today, but this has been a great discussion, a fantastic presentation. So I'm just going to say how glad I am to have both of you here and to have you working on behalf of child and adult survivors of family violence. It's so important. So thank you to both of you. Thank you also to our French language interpreters, Wendy and Carolyn. Don't forget to complete the evaluation form that will open automatically when you leave or when we close this webinar to receive a certificate of participation. And we look forward to seeing you all at the next webinar. Thank you very much. Bye.
Thank you. Bye.